Hello, everyone. I'm Lana Zach, and we are following breaking news from New York City. The largest judgment to date has been issued against former President Donald Trump. Judge Engoron has imposed a penalty of more than $350 million against Donald Trump, his adult sons, and his corporation in the civil fraud case brought by New York Attorney General Letitia James. Well, the former president is being ordered to pay more than $354 million in damages. His co-defendants are being ordered to pay another $10 million in fines. The judge has also banned the former president from conducting business in the state of New York over the next 3 years. Eric Trump and Donald Trump Jr. are also prevented from serving as an officer or director of any New York corporation for the next 2 years. CBS News investigative reporter Graham Cates is with us now. He's been covering every aspect of this trial. Graham, I've been highlighting. I have lots of questions for you. But first of all, what's your top line take from the report so far?
I think you nailed it. It's the incredible sum of money that Trump in particular and his company now need to pay the state. Of course, they're planning on appealing this. They've been planning that from the very beginning. I spoke to a member of the legal team on the second day of the trial who told me that they thought their end game was appeals, but they're currently on the hook for really an incredible sum of money. And he, as recently as last year in a deposition, claimed to have on hand about $400 million in cash. If you add this sum that he's been penalized with the amount that came out recently in the E. Jean Carroll trial, that more than tops what he claimed to have on hand. So it immediately creates an enormous cash crunch for former President Trump.
$354 million in this case, $83.3 million in the latest E. Jean Carroll defamation case. That's on top of the $5 million from the previous E. Jean Carroll case. And there was also a $1.6 million judgment against the Trump Organization for tax fraud in 2022. And that's on top of all of the other cases that continue to persist. Graham, one of the things that we've talked a lot about is how this has helped him on the campaign trail. And he has felt buoyed by this by his supporters who have also opened their pocketbooks. Given that we're talking about a tremendous sum of money, are Trump supporters able to help with these, not just legal fees, but with these judgments against him?
Yeah, no, it's actually a big difference. So their donations through their PAC, they can go toward his lawyers and that kind of thing. But when there's a judicial judgment against you, that has to come from your own pocket. The donors across the country can't contribute to this fine. So he and his company are going to have to be the ones to put this forward. And in order to appeal it, they have to actually put forward a significant sum in order to appeal it. It's kind of like a bond.
So explain that for our viewers who maybe are less familiar with that requirement here in New York than others. The president has announced even before receiving this judgment from Judge Engoron that they intended to appeal this. But the money from the judgment still needs to be set aside. Why is that? And if he is unable to come up with the amount of cash that is required, how does that affect his legal strategy moving forward?
Yeah, think of it as just kind of a guarantee. You can't in New York use an appeal in order to avoid paying altogether. You have to be able to foot some of it so that you're not just using the judicial process to delay what you've already been ordered to do. And how this ends up playing out, we have to wait and see. But we know they intend to appeal. And we know that they can't just entirely ignore the judgment while that's going forward.
All right. Graham Cates, thank you. Stick around with us. I want to bring in now Jessica Levinson. She is a CBS News legal contributor and a professor at Loyola Law School. Jessica, I want to ask about a particular thing that I read in this report that we just got from Judge Arthur Engoron. He said that he really hit hard the former president and his co-defendants in terms of them not assuming really any responsibility. I'm going to quote from the section that says refusal to admit error. The judge writes, their complete lack of contrition and remorse borders on pathological. I haven't read in any of the legal opinions that we've seen anything that's quite as harsh as that. What do you make of this ruling?
Well, I think it's emblematic of what we saw during the trial. The trial was a bit of a circus, and you certainly saw Judge Engoron really clash with the former president. I mean, let's be honest that when Trump took the witness stand, he treated that not really as a witness stand so much as a press conference and really railed against the judge, his clerk. That's why there was a gag order in this case, and really the entire justice system, both civil and criminal. With respect to that language, again, I think it really does exemplify what we saw in the trial. And let's remember that this is a judge who already found before the trial began in a summary judgment motion that Trump had committed fraud, and that this ruling is based on a finding of liability on 6 of the 7 other claims, of the 6 other claims in the 7-count complaint. Now, there are judges, I mean, we only talk about the big cases, but there are certainly judges who write like that. I would say I think it's probably more the exception than the rule.
All right. Another thing, as we're talking about this judgment, I want to quote another part in the summary. The judge writes, when confronted at trial with the statements, defendants' fact and expert witnesses simply denied reality. Given the amount of evidence that was presented, 40 witnesses, 43 days of testimony, what legal basis does Donald Trump have for his appeal?
So I think that the reason that the judge wrote that is that he said this is not a battle of experts. And I think and I will get to your question about an appeal, but I think the reason the phrasing goes that way is because what he really wants to do is show that this isn't what the defense claimed it was, which was, well, look, some people just value property differently, and property valuation is inherently subjective, and that's something that can occur, and we really just have a difference of opinion as to what's appropriate. And he's saying, no, there's reality, and then there's what you argued. In this case, I think the appeal would go to a couple of different findings here. Obviously, I think that they're going to say that it's too much in this case to bar Trump from asking for loans by any business that is chartered in New York, by saying that he can't be an officer of any organization or corporation or director of any officer or corporation that is situated in New York for 3 years, that they have gone too far in saying that there has to be an independent monitor of the companies for 3 years, that the amount is too high. And I think that the appeal will focus in on the idea that the banks made money off of these loans. So where is the victim here? $354 million is not appropriate when banks made money. I think, again, not my argument, but I think that would be theirs.
Yes, and the judge does talk about that. You brought up, though, something that most people have been fixated at this point just on that big headline of $354 million. But you mentioned something else, which is that for the next 3 years, Donald Trump and the Trump Organization and its affiliates are barred from applying for loans from any financial institution chartered by or registered with the New York State Department of Financial Services. That seems to be a wide swath, given that New York is the banking capital of our nation. So does that mean that essentially the organization, the Trump Organization, and Donald Trump personally will not be able to apply for any loans for the next 3 years?
At least for, again, those organizations that are chartered, or let's just say broadly based in New York, even though that's actually too general legally speaking. So yes, this is not just about the amount of money. And it's, of course, completely natural that we're focusing on that amount because it's huge. $354 million is a huge amount of money. But part of what Attorney General Letitia James asked for was other remedies, saying, I don't just want monetary damages. I want them to stop doing business in New York, at least for a specific period of time. Judge Engoron, and this is a little bit in the weeds, actually took back part of the remedy that he had given when he granted the summary judgment, the cancellation of the business certificates. And he said, I'm modifying my previous order. I actually think that makes his judgment a little stronger going into the appeal. But it is absolutely the case that what Letitia James asked for and what she got was not just a big amount of money, but to Trump and the Trump organization and his adult sons, don't do business anymore in New York and don't ask for loans in New York for at least 3 years. And again, we really don't trust you. So have this independent monitor who looks over your business for at least 3 years.
And one that the corporation itself will have to pay for. Okay, Jessica Levinson, Graham Cates, thank you for your analysis.